All right, it is 11:02, so we are past time to get started. My name is Mary Hess. I'm the supervisor of DeKalb Township, and I welcome all of you to our township building, where today we're presenting on fair housing, disability, discrimination awareness. And where this came from is last year, we had these folks up here to present on fair housing, source of income, so that you can't discriminate based on source of income. And this topic of conversation about housing accommodations came up. And so it seemed like a subject that maybe we needed to investigate a little bit further. And that's what led to today's presentation. So what we do at the township, we provide assistance to individuals who maybe need some funding to help with rent or utilities, and then help with other needs that they may have at that time. So we serve a lot of individuals in the community with various needs, and we saw this as a topic that would be valuable to present on. So with me today, we have Dean from RAMP. Dane, I'm sorry, Dane from RAMP. Yeah, it says it right there. That is going to be part of our presenters. We have Carlos from Prairie State, and then Jocelyn from Fair Hope Housing, and then two other individuals.
Jennifer from Prairie State.
Jennifer from Prairie State.
Sarah from Prairie State.
Okay. All right. So, and they are going to be following along with, they put this presentation together. So this first part, the presentation itself is going to be recorded. And then when we get to Q&A, we are going to stop recording, but we will stay on the Zoom call. And one of the things that I was asked to mention, so just so that everyone is aware of it, is we partner with the DeKalb Fire Department. And so if you know of an individual living in rental or in their own home that has limited mobility, in the event that there was an emergency, we provide the fire department with Knox boxes so that a master key or a key to the individual's home can be accessed through that Knox box, so that in the event of an emergency, the first responders can get into the house without having to do any damage to break doors or anything. So that's available through the DeKalb Fire Department, should anyone need that resource. And that is for people who own their own homes or not for rentals. So with that, I'm going to go ahead and hand it over to our presenters. Okay. All right.
Let's go. So as Mary mentioned, my name is Jocelyn Rios. I'm the Associate Director of Outreach at Hope Fair Housing Center. I'm going to talk pretty quickly or briefly about just fair housing, what it is, just some protections. I know that there's kind of like a mix of housing providers and also tenants, people who have disabilities. So we're going to try our best to just accommodate this presentation to kind of fit the needs for all of you that are here today. So we could just keep moving on. So what is fair housing? Under both federal and state protections, essentially what these fair housing protections do is they prohibit discrimination in really any housing related transaction, really any point in the housing process, whether someone is looking for housing, they're searching for housing, they're already in their housing, based on any protected characteristics, which we'll share what those are under federal and state laws. But essentially what fair housing is, it's just the right for people to kind of choose where they live, be able to utilize and enjoy their home, and that just come without any form of illegal discrimination once they're in or searching for their home. So protected classes. We'll start with the federal protected classes, and we can move on to the next slide. So under the Federal Fair Housing Act, there are 7 protected classes. The one that we're going to focus the most on today is disability. But there are 7 that you can see on the screen. So anything from race, color, religion, sex, nationality, and familial status. We can move on. So as I said, the core focus is, we can move on. So as I said, the core focus is disability. So disability was added as a protected class in 1988, and it focuses on anyone who may have a physical or mental disability. Maybe I should have had you.
Right click.
Yeah.
Sorry, left.
So under fair housing law, disability is defined as someone who has a physical or mental impairment that would substantially limit one or more major life activity. Of those activities,
I gotta find it.
gosh, not click on the next thing.
Everybody go
This
first.
is just a list of some of those major life activities. Obviously, those activities aren't important for day-to-day life. I'm gonna move this slightly over. But it could be anything from seeing, hearing, eating, walking, standing, just having that, just again, major life activity that impacts their day-to-day. All right, so the National Fair Housing Alliance always provides a trends report, and essentially under this trends report, what it does, it provides an overview of the amount of fair housing complaints and just shows what exactly or what protected class is impacted the most. And so through the 2025 trends report, it showed that 54.6% of these fair housing complaints were based on disability. Largely, it was the failure to grant reasonable accommodations or permit reasonable modifications. I know at Hope, this number is pretty similar to the amount of calls and clients that we get. So it's pretty on trend with what the National Fair Housing Alliance is seeing as well. Just gonna let people in. So as I mentioned, there were federal state protections. Here in Illinois, we have additional protections under the Illinois Human Rights Act. Some of the noteworthy ones to kind of focus on or touch on that have been recently added. Source of income was recently added as of January 1st of 2023. Immigration status was added, I believe, January 1st of 2024, and then reproductive health decisions was recently added last year. So those are some of the newest protections that were added to the Illinois Human Rights Act. So here in Illinois, individuals have these protections on top of the federal protections that we previously mentioned. And I think there's a couple of slides that will touch on source of income as well. And here they are. So source of income, like I mentioned, it was recently added into law as a protection January 1st of 2023. Essentially how it's defined or how it plays out is that it's the lawful manner by which an individual supports themselves and their dependents. So on the screen, there are a couple of examples of what source of income, what kinds of source of incomes or types of source of incomes are protected. That's anything from a housing choice voucher, anyone who may receive TANF, Social Security, disability insurance, healthcare benefits, things like that. Source of income discrimination, so how it looks, how as housing providers you should avoid saying or kind of doing these things. The first is just obvious discrimination. So if someone says, or if housing provider says, no Section 8, no housing choice vouchers, you have to have a job to live here, that's something you typically want to avoid. For any type of differential treatment, requiring certain individuals with certain sources of income, like those who receive housing choice vouchers, to undergo more background checks or just multiple screenings of their credit check, or just providing any other types of conditions because of their source of income, or just because of any other protected group. But in this case, we're talking about source of income. Discriminatory practices or policies. This is a big one, I think, especially when we're talking about source of income and when we're talking about those who utilize a housing choice voucher, is just how that minimum income policy is applied. So with housing providers, you might have a 3 times the rent policy. When we're talking about individual who utilizes a housing choice voucher, knowing that that minimum income has to be applied to the tenant's portion, not the overall rent. So just kind of keeping those in mind. All right, so just a couple of questions regarding source of income and just income in general. I think this largely pertains to housing providers. Can landlords still consider income? Yes, you're more than able to consider income. You can have these minimum income policies. Really the only caveat here is just to make sure that these are applied equally to everyone, and they're not used as a way to screen out people who may have a disability or who utilize other sources of income. So making sure it's applied equally, but just knowing that it's not meant to screen out people who are already protected under these laws. Right, what is not lawful under source of income? We kind of touched on these when we were kind of looking at just the different types of discrimination, how it might look or how it might manifest. So as for housing providers, saying we don't accept Section 8 or housing choice vouchers is a huge one. Refusing income because it is disability related. So again, it's just simply denying someone because of the type of source of income that they're using. Requiring someone to be employed, applying stricter standards or stricter policies or conditions for voucher holders. Like I said, this can have a disparate impact or disparate treatment of that individual. So things that may be lawful but can sometimes be misused and should just tread lightly and just cautiously. Like we said, you can still have your income policies in place. You can require total income in order to meet the threshold that you have and verify income stability. But just making sure that the formula that you used is applied in a manner that will not just deny vouchers outright, and then just calculating that income based on the full rent instead of the tenant portion when we're talking about voucher holders. All right, and so this kind of ties everything with fair housing in general. It's just a couple of discriminatory actions or prohibited acts. Just intentional actions would be anything like statements and advertisements. The biggest one that we said was source of income. Was no Section 8, no voucher holders, anything from sexual harassment, hostile environment, any type of retaliation, or steering. Some covert or differential treatment would be just lying about the availability of housing. No, you're good. Refusing to sell or rent, applying different terms and conditions. And this isn't just for source of income or disability. Again, this is also for any of those other protected groups and characteristics that were mentioned at the federal and state level. And just other violations that to be cautious of are policies with any discriminatory effects. So like we mentioned with the minimum income policies, making sure they're applied appropriately and accurately for voucher holders. And then for this section, since we're gonna kind of lead into disability and reasonable modifications, accommodations, just refusing to grant those accommodations and modifications. So I think you are next.
Yes.
That's up to you.
Before we move on, I just want to make sure if there are any questions from that previous section that you had. I'd rather get those questions out of the way just in between these little sections rather than. All good to move on? Okay. So this next section is going to focus on reasonable accommodations, which is a term we're probably familiar with a little bit, but just as a refresher, a reasonable accommodation is any change that can be made typically to a good or service that would make something more accessible for a person with a disability that is reasonably attainable and doable by the person responsible. And we'll go into a bit more detail about what exactly that constitutes. I'm going to move this. So, one of the big questions with reasonable accommodations is who pays? So this first section is focusing on policy changes. This might be altering an aspect of a housing policy, a lease, or something like that that makes it more accessible for a person with a disability to be able to rent there. For these types of changes, for policy changes, typically the housing provider would pay if there's any cost. Now, obviously, a lot of these don't require a cost. A policy is usually one of the cheapest and typically free things that can be changed. But if there were some sort of costs that were to be incurred by this, the housing provider would make that change, would pay for that. This is also pretty easy to not worry about who pays when the tenant moves out, because Physical changes rarely require any financial change. You can just change the policy back what it was if you're then renting to somebody without a need for that accommodation. Physical changes to the property are obviously a little different. These are permanent changes. They tend to have quite a price tag associated with them, and the expectations there are a little bit different. For the case of a reasonable modification of a physical change for a space, that is typically the tenant's responsibility in private housing, or at least to say that if a physical change needed to be made, it's unlikely the landlord would be held liable for that change. Sometimes the housing provider might be expected to pay if it's federally funded housing, like in the case of public housing, but private landlords are not going to have the same expectations to them. When the tenant moves out, the landlord can only require restoration if the change affects future use. So, for example, if somebody were to remove cabinets to make more room, that would be something that they would be arguably expected to restore if that reduces the amounts of cabinets available that would be expected. A physical change that would modify it in a way that would be negative for a future tenant, you would be responsible. But it's also got to be something that's reasonable to restore. So the example given here is grab bars, like those used in restrooms to make restrooms more safe. Those aren't impeding in anything else. It's not like lacking a cabinet where not having that cabinet is going to impact something. A grab bar really only offers a benefit, no detriment. So you would typically not be able to expect a tenant to remove a modification like that. Oops, I went backwards. Moving on to the tenant's duties. There are some things that a housing provider can require a tenant to do. First of all, a tenant does need to get permission before making changes, obviously. They can't just start removing cabinets or something like that without letting the landlord know first. They also need to have some sort of assurance that work will be done professionally with permits if required. So installing a physical change does not magically make any of the housing code requirements or construction code expectations go away. And it's not necessarily okay for them to just say, oh yeah, my buddy's uncle's going to do it. He's really handy. You want to make sure that they should be providing some proof that it is a reputable contractor. As I mentioned, if the change doesn't affect the next tenant's use, then that's not an issue. But if it would majorly change the next tenant's use, you can say that the unit would be expected to be restored to its original condition before they move out. For example, wider doors are not going to hurt anybody. It's pretty much a universal benefit. So asking somebody to put smaller doors back in would not be a reasonable expectation. And typically the requester does pay for these changes as well. So any changes that they made, they're responsible for paying for and responsible for the restoration after. One of the big things that reasonable accommodations do is they invite quite a bit of a conversation. And sometimes the landlord may not want to make these reasonable accommodations. This is where the concept of a direct threat comes in, and this is a common point of disagreement from housing providers. In order to prove that a change would make a direct threat as a reason not to make that accommodation, the housing provider is responsible for proving some things. They have to make it clear that the change would make a direct threat to the health or safety of others or the property of others, and that there are no alternative accommodations that will eliminate that direct threat. So it's a problem that the solution to a problem might invite a new problem that doesn't have a solution of its own.
Give an example.
In housing, it's kind of tricky, but a lot of the more common examples that I know are like in workplaces where if somebody's disability, say somebody had PTSD and they were a surgeon, might be prone to tremors or something that would impact their ability to operate or something. In the case of these, it is hard to think of examples of changes that you would think, which is what kind of makes it. Are there people who have found examples of direct threats that landlords have successfully argued? It's, again, in housing, it's not going to be a super common situation since most of the changes aren't going to be rare. But I suppose that one might be in a gated community. If somebody were unable to operate the entrance in, it would fundamentally change the security of it to say, oh, we just leave that door open now. But again, you could think of an alternative accommodation and making an automatic opening. So I'm curious if anyone else in the panel can think of or has any examples.
One that we see a lot is emotional support or service animals. Sometimes they have maybe a younger dog that they say is a direct threat. It may bite or it's aggressive, something of that nature. And the landlord will say that has a health or safety issue for other tenants in the building. So that becomes a big conversation piece because, you know, someone needs this animal and then the other tenants are like, we're scared of this animal. So what do you do? I mean, that's a lot of times when Prairie State would get involved. But one of the things they may do is say, this dog needs to go to training, or you know, puppy school or whatever you need to do to make sure that that threat is diminished. So that's one that we've seen in our work.
I think a pool would be an example too. A pool.
Sure.
I'll leaving a gate open for someone who have mobility issues, but then that can create a problem for a minor child or something on the property.
It's a good example. But then at the same time, we see another alternative accommodation that could just be changing the thing to be accessibly operable by somebody. So that's usually the idea of identifying a direct threat more often creates a conversation, I think, for coming up with alternative accommodations to support it. And as I mentioned, in the case of housing, there aren't so many safety concerns that will pop up as you would see maybe in a workplace, which is where a lot of the direct threat stuff tends to come in.
I have one. I know for direct threat, it could be like an issue, a work order that needs to be, but they can't fix it because it'll cause another threat to someone. So that's hard.
Whoa.
Another one would be someone maybe that's on medication for a mental health disorder. They become aggressive when they're off their medications, and then they become, you know, violent towards other tenants, or that becomes an issue. And then one of the things is maybe come up with an alternative to make sure someone can come in and make sure that they take their meds or something of that nature. But that would take that direct threat away.
This is all kind of a preview to the aspect that this usually invites a discussion, and it should, because there's no perfect panacea for every issue. But just opening the conversation and having both parties engaged in good faith is a way to find a solution that'll work for people.
And it's good to mention too, that if you don't partake in that interactive process, that's like saying no. So you have to take part in that process of coming up with a solution.
So some key elements to reasonable, we see the abbreviation reasonable accommodation or reasonable modification, two sides of a similar coin there. Housing provider has to know that the tenant has a disability for them to request it. If a tenant were to just request a reasonable modification, but not claim or have any documented disability or anything, obviously that's going to complicate that request. You need to make sure that the accommodation or modification is necessary to address the effects of the disability. So somebody who has a disability that doesn't affect their mobility can't really request a modification for a mobility related reason, but they could of course request it for anything that their disability does affect. The tenant has to request the reasonable accommodation or reasonable modification. A housing provider is not expected to just anticipate or predict a change. Even if a new tenant, say, has a disability that you're aware of, you don't have to, initiate the change to be like, do you want a modification? They are expected to ask, and they usually will if they need it. What exactly defines the reasonable aspect of a reasonable accommodation or modification? The two main things you want to look for is that it doesn't impose an undue burden. So that's financial and administrative. So if somebody were to request something that were just financially not feasible for a landlord, the landlord couldn't be expected to do something they cannot do. Or if the administrative burden would be too much of a change in policy that it would impact things, that's a reason to not have a modification or accommodation. The other aspect is that it doesn't require the housing provider to fundamentally alter the nature of services. So like I said, if part of the service is you have a gated community and part of the modification would be leaving that gate open, that would fundamentally alter the nature of the gated community. If somebody were to make any request that would ultimately change it, that would be a grounds not to support it. And as we mentioned, the no direct threat. If you cannot establish that the modification would provide a direct threat to somebody's personal safety or property, then you're gonna really struggle to deny that unless it's also falling into those others. Yeah.
The undue burden as related to finances, is there any guidance out there as to what is under and over?
I don't want to say something wrong. I remember hearing that there was some percentage a while ago. I probably could have anticipated that question, but it's usually a case by case thing. It depends on like the size, obviously the financial expectations for a large rental company would be very different from just an individual tenant. But I don't want to give a number just out of the top of my head, so I can get back and try and find that.
Thank you.
All right. Next, we'd like to talk about, as I kind of alluded to before, the interactive process. As I mentioned, a reasonable accommodation is not just some form that's handed out impersonally and then it's either signed or rejected. It should be an interactive process between people to try and find the best solution possible. Because ultimately, every tenant is going to want to be able to live comfortably in their homes, and every housing provider is hopefully going to want the same. Everyone should have those same goals. So housing providers must engage in an ongoing process to evaluate reasonable accommodations or modification requests. This would include gathering information that would be needed to assess a request and discussing alternatives. You are not necessarily required to just give whatever reasonable accommodation is requested. You need to provide a reasonable accommodation if it's requested and feasible to do, but their specific request is not mandatory. You are obligated to engage in a conversation to find a solution that works for everyone, but you do not just have to give whatever is demanded or requested. We see here the kind of cycle of how this can be ongoing. It starts out with a request for an accommodation based on an obvious need or supporting letter, usually from a physician or another medical doctor. The gathering information stage, in which you review the request and the verification just to make sure that it's legitimate. Explore alternatives if needed. I mean, if at this step you're like, yeah, we could do that, then congratulations, you've solved the problem and reached an ideal situation. But if that's not going to work, your next obligation is to explore alternatives. Your response is, I can't do that. Your response is, I can't do that, but here's what we might be able to do, or here's another idea that we can do.
And is this something RAMP, this process, is this something RAMP can
Yes.
assist with?
This is the sort of thing that nonprofits like RAMP are here for. A lot of times these conversations can be a little uncomfortable when they're just one versus one, or I shouldn't say versus, but one person and one person. RAMP is happy to provide advocates to function as a third party to help smooth the conversation and make sure that everyone is aware of what rights they do have, what expectations they should have, and make sure that there isn't any misalignment there.
In your experience, do these conversations tend to happen before a lease is signed or after?
Typically, I don't work directly with people. I would say it's more common before.
I did. I worked here for a few years as an independent living specialist. Most of the time, people that I've worked with, it happened after the lease was signed, because some people are nervous to have those conversations before the lease is signed, because they think that, well, if I ask all these things, then they're gonna be like, well, no, I'm not gonna rent to you. So yeah, most of what our experience is after that lease is signed.
Okay, all right. Thank you.
Which does kind of invite the suggestion to housing providers that you should be open and direct about willingness to work with reasonable accommodations, to make that a part of your application process and make sure that you are not discriminating against anyone after that fact, because this is a right that people have either way. You might as well get ahead of it and initiate the conversation rather than wait until after. And then finally, implement and monitor. You do the solution that you choose once you figure out what works best. Note that the requester is the best to know about what will work best for their disabilities. So take their requests seriously when possible. If you're denying because you absolutely can't do it because of a financial burden or a direct threat, that's one thing. But if you have one option that would really help them, that's harder, and one option that would kind of help them, that's easier, you should go for the one that's going to help them the most. And then once that is, implement and monitor and see if it works. If that solves the problem, congratulations, the process has succeeded. If more accommodations are needed, then you initiate the process again. So here's a fun little example, have a audience participation if anyone's willing. Here is an example of how the interactive process might go for a tricky situation. So a tenant makes a request to transfer to a first floor unit in a building without elevators. There's no first floor unit available. What should the landlord do?
Assuming that the property will have a wait list, place them on a wait list, and as one become available, based on a accommodation, a reasonable accommodation, that tenant would get the unit.
That could be an option, and if the person is willing to wait, that would be a good solution. But if they can't access, usually this request is happening because somebody acquires a disability, right? They were able to navigate the stairs, but they aren't ever any longer. So putting someone on a wait list is a nice offer, but that might not be a solution that will work for them.
Cause they put in like a stair lift,
A stair lift is an option, but again,
it's gonna change a threat, maybe.
not really. They're designed safely, but my bigger question is, does the landlord pay for that?
Oh.
Because recall that the tenant is responsible for physical changes.
Mm.
So if the tenant were to offer, hey, I've got the money or I found funding that will install a stair lift, your answer is yes. You're getting a stair lift installed, which immediately opens you up to more potential tenants because they see it as a more viable property, and you're installing a key safety feature. I'll tell you right now, the landlord does not have to build an elevator or build a new apartment for them. That would be an undue financial burden. That's obviously a big expense. Another option that might be worth is a policy change. Offer to nullify the lease without penalty of any early cancellation or move out, and maybe offer to assist with move out fees if you're willing to do that. The point of this is that this is a tricky situation with no clear one obvious solution, but we talk and we find solutions that might work. If the person can wait until the wait list opens, if they say, yeah, I can go a month and manage it until the thing opens, then sure. If it's, I'm gonna be stuck upstairs half a year, then that might not be a solution. If they're willing to move, then making it as easy for them to get out without fear of any negative penalties, that's a possible solution. Being accepting when they say, I'm willing to pay to install a stair lift and I have a reputable contractor, that's a pretty reasonable accommodation. That's getting someone to do something, an improvement to your property for you. It's all just part of the conversation to find out what works best for that situation. Here's another example for the question of financial burden. A tenant with a disability can't take the trash to the dumpster and ask maintenance to come to the apartment to take the trash to the dumpster. What do we think here?
Like a reasonable accommodation.
It's going to take 5 minutes for staff you probably already have to do. That's it's hard to call that a financial burden. You're going to try and say you need to hire an entire new staff member to take one person's trash to the dumpster. It's probably not going to fly. This is a pretty reasonable accommodation to ask because it doesn't really change the fundamental nature of the service. In my mind, I think this is a pretty clear example of not a financial burden. If you were asking to install a whole garbage chute, that's a pretty major change. But asking one of your maintenance people to, hey, once a week, can you take this person's trash to the dumpster? Pretty reasonable.
Now, how would that work for a private owner?
That becomes, again, that's part of the question. If that becomes a bit more of a financial burden that the person would have to travel out and fundamentally change it, then maybe not so much. But an apartment with a dumpster is usually going to have a maintenance person. It's usually going to have something like that. In the case of a private house or something like that that isn't connected and has its own, maybe that becomes a bit more. Again, maybe that's still not that much to ask of a maintenance person. That's a question for you to determine on your financial aspect. And if that's not the case, then you seek to find another alternative that if I can't come out personally, we find somewhere that can. The point is you're engaging in the process. Okay. Moving now to service animals, emotional support animals, and pets and the distinction between them. Service animals and emotional support animals are different things. A service animal is legally defined. It is the subject of federal legislation, the ADA, that defines what it is and the rights that people who rely on them are able to do. A service animal is specifically a dog and, in rare cases, a miniature horse. Or for rural areas, if anybody finds a person with a miniature horse, please let us know. I've never actually heard of one.
Yeah, I've never seen one either.
But that is the two legal defined service animals. If somebody says their cat is a service animal, they are wrong. A service animal is also individually trained to perform specific tasks for a person with a disability. So examples of tasks, I think the first one that comes to a lot of people's mind is a seeing eye dog, which guides someone who is blind. But it's important to note that dogs that are service animals can come in any breed. If somebody has a small, like say a Chihuahua or something, and you might think, okay, how could that be a service animal? Well, they have incredible senses, and they can detect when somebody is about to have a seizure, or having low blood sugar, or having an irregular heart, or having an oncoming PTSD episode. So dogs can be trained to do a variety of tasks other than just physical ones. They could also pull a wheelchair, and so on. So if somebody has a service animal and it's a dog, that's a clearly defined thing. Somebody's parakeet is not a service animal. As I mentioned, they're covered under the Americans with Disabilities Act. They are allowed in public places, and they cannot be subject to pet fees. In addition, you're allowed to ask 2 questions when determining, because a lot of the people first concern is, okay, what if somebody just brings their pet dog that isn't a legitimate service animal? What can I do? You are allowed to ask 2 questions to determine the legitimacy of that claim. Is this a service animal required because of a disability? You cannot ask what the disability is. That's private medical information. But you can ask to confirm that it is a service animal. You can also ask what task is it trained to perform, so that you know what to expect when you see the dog doing it. You might want to see it do it, but you can't ask it to do it on the spot, obviously, because it's trained to do it in response to the thing happening. It's just going to confuse the animal if you say, oh, imitate it. But that just shows that there's a wide variety, because some people might see a dog come walk around the full scope of a restaurant and be like, well, what the heck's going on? Well, you could ask, is this a service animal required? What tasks is it trained to perform? And they might say, yes, my dog goes around. They might choose to disclose that they have PTSD, and that the dog looks around for anything that might be potentially triggering before I walk in, so I know it's safe for me to enter. Okay, cool. You can't ask them to prove it, but you can ask clarity. What should I expect this dog to be doing, and is it a legitimate service animal? Emotional support animals are a different thing. They can be any type of animal. They can provide comfort or emotional support, but they are not trained to perform specific tasks. These are animals that do provide an important role in handling people's needs, but they are not specifically service animals. So this is where somebody's cat could become recognized as an emotional support animal. Something to note that emotional support animals are not allowed in public spaces like service animals are. If anyone tries to say that they are allowed to bring their cat on the bus, they are not, unless the bus's policies allows them to. They are, however, covered under the Fair Housing Act. While they are not subject to protections in public spaces, in housing, it is considered a reasonable accommodation to have an emotional support animal. If they have an emotional support animal, you cannot charge them pet fees, you cannot restrict the breeds. Any policies that you may have that would affect people's pets do not apply to these, because they are protected under the Fair Housing Act as not pets. They're not service animals, but they're also not pets. That being said, landlords can request documentation if the disability is not obvious. So if somebody has an emotional support animal and you are not aware that they have a disability, and they don't obviously have a disability that would necessitate it, you can ask for documentation to prove that they have it. That would be provided from a medical professional. They don't even have to disclose. The doctor would, they know exactly what they can and cannot say in those, but a medical doctor could provide proof that the emotional support animal is needed. Finally, we have pets, who we all love, but are not subject to as much legislation. A pet is any animal kept for companionship and not for a disability-related reason. They're not protected under the ADA or fair housing laws, and you absolutely can charge pet fees and deposits, enforce breed or weight restrictions, or deny pets entirely. Service animals and emotional support animals for the purposes of housing have protections, take them seriously, but you are obviously allowed to have whatever pet policy you choose. Oops. Some lawful requirements that landlords can set about service animals and support animals. These will apply to both. You are allowed to expect them to have vaccinations if the law requires it. Illinois does have vaccination laws that, oh man, this is a little finicky. You can also have any licensing required by local ordinance. So any local ordinance that expects any animal to be licensed in whatever way, you can expect that. The animal must be controlled and not dangerous. So again, this gets in that situation where if even a ADA protected service animal is providing a threat and the owner is not able to get under the control, you can ask them to remove it from the premises. And any actual damage that any service animal or any emotional support animal causes, the tenant is responsible for. However, you're not allowed to do pet fees or deposits. You can't expect certification or registration requirements. Some people have little cards that say that their service animal is officially licensed. There is no such thing. They spent $50 online for a piece of paper with no enforceable power. They are welcome to carry that around, but they aren't required to. To that end, you can't ask a service animal, hey, is this prove it with some sort of license, because there isn't one. You can't have any breed or weight limits for either of these because, as I said, they have a variety of roles. You might need a big dog to do the roles. You might need a small dog to do the roles. And you also aren't allowed to show training requirements of any kind for service animals or emotional support animals. That's my section. I know that's quite a bit, and they're always the subject of some concerns. Any questions before we move on?
There were some questions in the chat.
Oh, okay. Let me see. Can you ask for supporting documentation? I think I've answered that with what you can. For an emotional service animal, you can ask, or if, and I believe for a service animal, if the disability is not obvious, you can ask for a doctor to confirm it.
I do want to say for fair housing, it does not just have to be like a medical professional or therapeutic professional.
Okay.
It just has to show like the nexus between, they have to have a relationship and show the nexus between the reasonable accommodation and the person with the disability. So they could just provide that information in a letter.
Similar.
Yeah, it could be a social worker, counselor. It could also be someone, you know, if if they've worked extensively or have if they're working with a social service organization, and they have they're receiving client services there, they can, like, that organization can also provide that letter. So it does not have to be specifically just a medical or therapeutic professional. It could be another third party.
Thank you for that. That was the last word. Does the landlord have the right to ask for certification? I believe I answered that by saying that no certification is legitimate. So it is just sort of a sort of thing where anyone can provide documentation and say, yes, they have a service animal or an emotional support animal. But as I mentioned, any vest that says service animal doesn't mean anything. Any certificate doesn't mean anything. The spare neutered thing, I can't answer that. I don't know anything about that.
I'm not honestly sure of that too, but I could try to find out and send that information over to you and we can send that information.
I haven't heard that either.
I suspect it would kind of fall under the local ordinance type expectation, where if there's a law that says it, that they wouldn't be exempt from it, but otherwise, I don't know. That's an interesting question. Is it correct it's only one emotional support animal per person? I also don't know that.
Not necessarily,
I
no.
don't think so.
It's dependent on the person's disability and what that, it's if they were to do another reasonable accommodation request, what is the need for that accommodation request, kind of showing that relationship. And sort of nexus between the need of that request and the person with the disability. So, no.
box. I think I'll
Just put it on the X.
Are there any questions in the audience? I know that last year when we did the affordable housing or the fair housing, this was a big question and it seems like landlords deal with this a lot. So if a landlord, whether they're online or here, has questions, should these come up, who would be the of the panel, who would be the most appropriate organization to contact with questions?
Any of us, really,
Yeah.
I think, could answer the questions.
Yeah.
And then do you want to talk, maybe just take a moment to talk about what services you mentioned briefly that RAMP can meet with a tenant and a landlord? Are there other things that services RAMP can provide?
So all of our services in general are, by the way, for people with disabilities and free for people with disabilities. So I would say that we're happy generally to provide information to anyone who calls, but as far as ongoing service, we typically be there on behalf of the tenant more than the landlord in most of the experiences, because that's who our services are provided for. But really any sort of dispute, generally for more legal stuff, our move is to recommend them to Prairie State. But we do all sorts of services for people with disabilities. In the context of housing, I feel like that's going to be our main one, but never hurts to say if anyone's students, if your children are not getting their educational rights respected at their school, we have youth advocates who can help out with that. I help people file complaints. So if somebody is just not budging and violating the ADA, I can help them fill out those to hopefully get those addressed. We do offer our services to anyone with a disability of any age, any disability. So,
And it can be I work for RAMP too. It can be an undiagnosed disability as well. So if you're not sure, I always use the example of anxiety. We can assist you with that. All of our services are completely free. And like if someone is wanting to apply for housing, but they have no idea where to even begin, we can help them with the entire process. If they do need to get hooked up with one of these other organizations, we help make that referral. We do like a soft handover. It's any barrier someone has due to their disability. So it's really kind of the sky's the limit. It's really whatever someone is needing on an individualized basis. And you set the goals. We don't tell you what you need to be working on. We have that conversation with you and you're the driver of those goals. And you don't ever age out of working with RAMP. So.
Thank you. All right, so next we have Jen from Prairie State who's gonna
Talk a little about,
I actually have two
caregivers.
questions,
first,
if I can.
Carlos, do you want to talk just a little bit about Prairie State?
Okay. Hello, everybody. My name is Carlos Orr. I'm the Community Resource Specialist for Perry State. Let's give you an idea what Perry State do. We have three pillars that's very important: safety, financial stability, and housing. So Perry State is a non-for-profit law firm. So our job is to, I basically say, fight for people who can't fight for themselves. So we fight for when people need someone to fight for their benefits, SSI, disability, Medicaid, things of those nature. We get involved once you deny. That's when we get involved. We also help people if they're going through evictions or foreclosures. So we get involved as well. We get involved if the only thing we do criminal, I wouldn't say it's criminal. We help with orders of protection. That's something we're very, very serious about. Orders of protection. If people are victim of trafficking, our law firm would definitely get involved and try to stop that or be an advocate of that. But I don't want to take away from fair housing. I think it's very important to say this. When people think of a law firm, especially the home providers, I'm a home provider. I have two properties. Like, oh man, they're against me. What's important to know is that Hope Housing, Perry State, and RAMP, our job is to serve the community, but also to serve the people in the community and the people who are part of that community. And those are home providers. And sometimes we're just trying to educate you what to do, what not to do. But we also educate our tenants. That's very important. They have to follow policy. They have to follow rules. Just real quickly, I have a property, and I said this before. I didn't know I was doing something wrong. I didn't rent people who wasn't married. I figured, y'all, that's your boyfriend, or he might lead them on, then you stuck with the rent, then I'm stuck with the responsibility. But I can't do that. But I didn't know that. I actually thought I was doing the right thing. I also didn't move. I had a building with it's 6 units, and I had mostly seniors. And I had a young lady come. She was a working young lady, but she had 4 kids. I was like, no, because my seniors, you're gonna disturb their peace. But I know I couldn't do that because it wasn't a senior building. So we try to educate people because we want everybody fair, means to treat people right, to do the right thing. So that's for the owners and it's all for the tenants. So we're not just fighting for the tenants, even though we advocate for the tenants, but we also want our tenants to be responsible. We want our tenants to do things properly. So that's what's important when we think about fair housing.
Well said. So now we're gonna talk a little bit about live-in caregivers. Let's see if I can switch here to the left one.
Yeah,
Okay.
do that one.
So what is a live-in caregiver? Or a live-in aide is a person who lives with a tenant with a disability and they provide necessary supportive services and they would not live there except to provide care. And it is recognized under the Fair Housing Act and there is guidance from the Department of Housing and Urban Development or HUD regarding live-in caregivers. Are they considered a tenant? The answer is no, they are not a tenant. They do not have a leasehold interest. They are not financially responsible for the rent, and they do not have independent rights to the unit. They are considered a reasonable accommodation, not a co-tenant. Should they be listed on the lease? They should be listed, but not as a tenant. They would be listed as an authorized occupant or a live-in aide and included for screening and identification purposes only. So they can look at their background check, things like that, but they cannot apply criteria that would effectively deny the accommodation. So they are there basically to just live in and help with the disability. Do caregivers have rights under the law? They do have some limited rights. They are allowed to live in the units as an accommodation, and they are there to protect, they are protected from discrimination tied to the tenant's disability. They have no independent tenancy rights. So if the tenant leaves, they have to leave. They cannot take over the lease, remain as a tenant, or claim like succession rights. So there are some do's and don'ts for landlords when it comes to live-in caregivers. They have to verify the need for the live-in aid, especially if it's not an obvious disability. And that's one thing that I want to mention, like if it's not obvious, that does not mean the disability is not there. So don't always assume that you can see it physically on the outside. They can require basic screening, criminal background checks, and they can require the aide to follow the lease rules. They have to have, quiet enjoyment of the property. They cannot damage the units. What landlords cannot do, they cannot deny the live-in aid if it's necessary for the disability. They cannot charge extra rent or fees for the aid. They can't count the aid as part of the occupancy limits, and they cannot require the aid to sign the lease as a tenant. Does anybody have any questions on caregivers? Okay. So now we're going to talk a little about fair housing complaints and relief. I did want to mention too, Prairie State, when that interactive process is going on, when things start to break down and there's just no budging on either side, that's when a lot of times people will come to Prairie State because we have attorneys on staff that can help with those interactive processes. They're very well versed in those issues. So if you file a fair housing complaint, a tenant files a fair housing complaint, they have 1 year statute of limitations from the date that the occurrence happened. There's no cost to file with HUD or IDHR or even with Prairie State. It is a lengthy investigation process. It is not slow, it's not quick. I mean, it's gonna take a very long time to get through that process. But there are lots of conciliation opportunities and it is pro se friendly. A lot of people can file their own HUD complaint. It may go in further and then they're like, this is more than I can handle, and Prairie State can step in at that time if we take the case. And if they file in state or federal court instead of with HUD, then they have a 2 year statute of limitations. So that gives them a little bit extra time to file. It usually involves court costs and then they have to do discovery. But they can get injunctions to stay like in the property or punitive damages. And they can file like duly, they can file with HUD and in federal court at the same time. So there are remedies for people that have disabilities or any protected class that is, there's a discriminatory issue there, but they can maintain the housing, they can request policy changes, they can receive monetary damages, including emotional distress, loss of housing opportunity costs and expenses. They can get injunctions and temporary restraining orders. They can ask for attorney's fees and costs. There may be civil penalties involved as well to vindicate public interest. And they can also have punitive damages set to deter future conduct. You will see like in articles like with banks and things like that, they will set damages for them to correct their issues. And that is really all I have to say. Do you have any questions?